Good morning and welcome back to our part 2 of the answers to your questions for the American Rescue Plan Act and the outbreak period. My name is Casey Hope. I'm the Marketing and Communications Director here at Medcom Benefit Solutions. We've already had a couple of questions come through this morning about the slide deck. The original presentation that we did a few weeks ago, the slide deck was released to the registrants and participants. It is also available to watch via our YouTube channel. Medcom Benefit Solutions is on YouTube. Also, we did send the slide deck to the questions from last week out to participants and registrants as well. And you will get a copy of the questions, the slide deck, the recording, everything from this morning's session as well. So yes, this session is being recorded and we are going to be able to provide you with that information after the webinar closes today. As always, I'm joined today by Michelle Barki, our Senior Legal Counsel and knower of all things here at Medcom Benefit Solutions. We are certainly lucky and super thankful to have her during these times when everything is under question and everything is changing on a daily basis. With that in mind, we do want to let you know that the guidance that we are providing today is based on what we know today. The IRS has not issued any further guidance. In fact, on their website, this statement is listed. The IRS is reviewing implementation plans for the newly enacted American Rescue Plan Act of 2021. So what that means is that what we know is very limited. And so some of the questions that you guys may have posed to us, we may not have the answers for right now. And we would rather say we don't have the answer than to certainly steer you in any direction that could be wrong in the future. So with that being said, we're going to go ahead and get into the questions that we do have answers for. And today we're going to start with dependent care. So Michelle, I'm going to go ahead and start reading the questions for you. This question has a very long answer. So if I have a dependent care plan that runs on a plan year and renewed on 8/1/2020, can they allow their employees to increase their current elections 1/1/2021?
Yes, the DCAP rule said that they could go back to 1/1/21. And when the IRS looks at DCAP, they're looking at it on a calendar year plan and how much money is actually spent on a calendar year plan. So the American Rescue Plan Act of 2021 did allow for that increase to $10,500 for single and $5,000, and divide that by 2 to get the amounts that if you're filing jointly, each can, or separately, each can claim. Now, we always want to give our thoughts about whether or not you should increase to $10,500. And again, the employers do not have to allow that. One of the things I would always ask is where you stand with your DCAP plan. For an example, if you were to do a run of all the elections that you had this year, did anybody even hit the 5,000? And if they didn't hit the 5,000, would they actually go to 10,500? So you've got to know what your employees are doing before you make, at least that's what I would do before I made any decisions as to whether or not to go back. The second thing we're always worried about is the non-discrimination testing. As you know, DCAP is always subject to non-discrimination, and it is one of the benefits that fail tremendously with non-discrimination. And the 55% average benefit test is where they may fail if you go up to the 10,500. And it is the test that fails the most often. This test requires that non-highly compensated employees make up at least 55% of the DCA benefit. So consider who is participating in your DCAP and who is likely to increase their election to 10,500. You may also want to consider having NDT testing completed for the DCA plan if you want to change it and go to that 10,500. So always remember that that is one of the big concerns with increasing this to 10,500. The second change issue is that the government did allow us to make mid-year election changes on the DCAP, and they allowed us to extend that grace period for 12 months. Now, how it works with the DCAP is that if money is spent during that DCAP grace period, and this is in regular years as well, then that money that is spent during that DCAP grace period, and plus the money that they elected, might go over the $5,000 on a typical year. So for an example, if they carried over $1,000 and then chose to have $5,000, you as employers are completely in the guidelines and safe harbors to put that they elected $5,000 on their W-2. That's completely legit. You don't have to worry about the $1,000 that they carried over. But the individuals at the end of the year, they have to reconcile their DCAP benefits with the IRS. And they do so on Form 2441 with their tax returns. And if they have spent more than the $5,000 because of the grace period, then they risk the chance of they're going to be taxed on it, on the balance. So we believe that when the IRS, and there's hints to this out there, that then when the IRS raised the DCAP to $10,500, they did so because they wanted to make sure that individuals who had that carryover period, and when they carried over the monies last year into this year and then elected this year, would not exceed the benefit and not be taxed when they did the Form 2441. So that is a separate consideration that you always need to look at. And then the other thing that we need to look at, for those who extended the grace period to 12 months or carried over for plans ending in 2021, we are going to run into the same situation as we do normally, that they can only spend $5,000 in 2021 into 22. So if they carry over the monies into 22, plus with that grace period, plus they elect $5,000, they're going to go right back to where we start with that Form 2441. That $10,500 is only for this year. They did not give us that same compensation for next year. Things may change. They may consider doing it next year, but at this stage of the game, we're only looking at 2021. So for these reasons, I would be very hesitant, or I would make sure that the employers understand what the employee is going to run into and whether or not we're even going to pass that non-discrimination testing. So beware of that increase to 10,500.
Thank you, Michelle. For dependent care change, can we pick any amount from the 5,000 to the 10,500 if we don't want to offer the full 10,500?
Absolutely. Employers have the flexibility as long as you don't go over that 10,500.
Are dependents, a divorced spouse on COBRA, eligible for their coverage to be paid for as well?
No, the qualification is that the only qualifying event that actually counts is the employee being involuntarily terminated from his job or having a reduction in hours. Spouses who obtain coverage through COBRA for divorce, that's not part of the, that is not part of the subsidy.
Okay. Is the DCAP increase retro to January 1st, 2021, and can a participant submit receipts for reimbursement on expenses incurred?
Yes, if the employer wants, they can go back to January 1st, 2021 and make those retroactive adjustments, and then the employer, the participant, would be able to submit receipts.
Regarding FSAs, is the temporary increase to the annual limit for dependent care only available to those currently who are participating in an FSA?
This is entirely up to the employer. Again, if the employer wants to increase the level to 10,500, and if they want to allow for mid-year election enrollments, they can do that as well. But again, I would be very hesitant before I opened up that 10,500, make sure that you're not going to reach non-discrimination issues and the other issues that we talked about.
Okay. Right, we're going to move on to questions and answers about the notices that are coming out. First one, Michelle, who is creating the notices regarding the new guidance issued on 2/26/21 by the DOL and the IRS?
Okay. The plan sponsor is technically responsible for sending out the notices. The DOL will not provide model notices for the outbreak period, just as they did not provide model notices for the outbreak period when it first came out last year. They are going to provide model notices for the subsidies, and the model notices should be available on or before April the 10th. Employers should always check with their COBRA administrators to see what the process is going to be to get these notices out and what the costs are going to be.
What should you do if a plan sponsor changed COBRA administrators and neither the current nor former administrator are facilitating the notifications?
Yeah, this is an issue that we have heard has been arising, and there is no clear-cut answer. I will tell you at Medcom Benefit Solutions, if we are the new carrier and if we can get all the information from the employer on who terminated and et cetera, we will be more than, and we have a certain format, and we've advised our employers of this, that we would be willing to get the notices out. Technically, it's the plan sponsor's responsibility. I hope that others will step up to the plate.
Will Medcom be sending out the notices for current companies who use them as their TPA for COBRA?
Yes, these notices probably went out, I think, a couple of days ago with the information on the outbreak period. And we just made a little note on the subsidies because we are still waiting for the model notice for those. But you should have, if you're an employer and you have Medcom, you should have already received a notice.
Yes, Michelle, and I can confirm those did go out to our employers and brokers yesterday. If you did not see those come through, make sure check your spam filters for one thing, and then also just send us an email and let us know. When can we expect to see a copy of the notice or letter, which is something we just covered here, but for clarification, Michelle?
For the outbreak period, we did send out the notice. We did send out information on that yesterday to the employers, and we are still waiting on the ARPA for the model notices to come out from the DOL.
Do you have to notify every member that was terminated since the start of the national emergency period? Is Medcom doing this as a COBRA administrator?
Basically, Medcom is doing this as a COBRA administrator, and this is for all those employees that would still be eligible to elect COBRA. March of 2020 is when this started. We've already been through March, basically. So yes, they should be notified, but mainly April forward.
How many notices does the employer have to send out regarding ARPA? We see the general notice and the notice of expiration of subsidy, but for some reason we thought there might be a third notice.
Yes, the 3 notices are going to be the general notice, which is the notice of availability of the subsidy, an election of the subsidy, and a termination of the subsidy. So those are the 3.
Okay. All right, and now we have some general questions and the answers that go along with those. If the plan that was in place at the time of initial COBRA eligibility has since been replaced, does the assistance eligible individual have the right to elect the replacement plan, even if the premium is higher?
And this has been greatly debated, and I'll tell you, I've talked to many other attorneys, and we all think, and again, the IRS hasn't given us any notice, but we believe the answer is going to be yes. If this is the only plan available, it would most likely be eligible. We also think if the plan has comparable coverage to what he had before, most likely would be covered. And even if the employee upgraded at open enrollment, we believe that it would also be covered, but we are waiting for clarification. The reason being is these are rights that the employee already had, and we believe these rights will continue to be enforced. It's just for those that, you know, in a regular 18 months between April the 1st and September the 30th, the no open enrollment, no other rights that they had, then they could, if the employer so allowed, they could reduce the benefit but not increase it. But we believe that if they have a separate right to enroll, or if the plan terminated and they had a separate right to enroll, we believe at that stage of the game, the IRS will say that that's okay. But again, as Casey noted at the very, very beginning, we are still waiting for further clarification. And if this changes, we will certainly keep you up to date in further desktop discussions like we're having today, and it will also be on our blog. The good news is that the notices for the COBRA subsidy don't have to go out until May 31st. The model notice won't even be out until April the 10th. So we're hoping a lot of these questions will be clarified in the very near future. I can tell you the IRS has been concentrating more on getting those subsidies to the individual than they have to be answering all the other questions that have been posed by the American Rescue Plan Act.
Thanks, Michelle. Will the ARPA credit apply to employers that benefited from the PPP loans?
Okay, a good rule of thumb is that there is never to be any double dipping. So if you got a PPP loan and included in the loan, you were paying the employees share of the premium while they might have had a reduction in hours, then you cannot double dip and get the monies from the PPP plus the monies from the American Rescue Plan Act. So just always keep in mind that there's no double dipping.
What if an employer has a new plan or carrier? Assume the new carrier must take an individual as a 4-1. So the employer started with the carrier 1-1, and now they have a COBRA participant who was never covered under this plan as a 4-1.
Again, as we mentioned, we believe that if they have a right to elect, if they have a new plan or carrier, we believe that they would still be covered if they meet the definition of an AIE. In other words, if they were involuntarily terminated or had a reduction in hours, and they have not been offered coverage elsewhere, and that includes Medicare, group coverage elsewhere, or Medicare, then we believe that they would be eligible for that subsidy for the period of April 1st through September the 30th.
For those that had non-medical COBRA termination during the outbreak period, should they be offered the option to re-enroll?
Yes, if they were a COBRA eligible benefit and they had a triggering event that caused the loss of coverage. So if you're talking about a vision plan or a dental plan that some do not consider a medical plan, even though they are, then yes, they would still be eligible. If they were eligible for COBRA and they're in the outbreak period, yes, you would need to offer them coverage.
If someone had family coverage as an active employee and left the job involuntarily, selected COBRA for himself only, can he add his dependents during the special enrollment even if they were not previously on COBRA?
The answer appears to be yes, because the individual involuntarily was terminated. And the rules that have come down, or that were actually part of the law that were pretty clear, is that you did not have to have COBRA prior to April the 1st to September the 30th in order to be eligible for that subsidy and put on the plan for that short period of time. So if he had qualified beneficiaries, they would be entitled to go onto the plan, we believe, from April the 1st to September the 30th.
Okay, now we're going to move on to some subsidy related questions and answers. For self-funded clients in the COBRA subsidy, do we continue to use the 4-tier equivalent rates and not the admin fees for the subsidized premium and the 2%?
If this is how you were doing the COBRA rates in the past and what you expected the employee to pay in the past, then yes.
This person says, I believe that the HRA funding amount is added to COBRA premiums that employees would pay for. So would the subsidy include this amount for the HRA, or do COBRA administrators have to strip out the HRA and then bill the members directly?
Well, the HRAs are considered a health plan and they are entitled to that COBRA subsidy, so that I would not strip it out.
Okay. Does the employer have to request for a subsidy refund, or can they automatically deduct the amount of the COBRA premium from their payroll taxes due on their 941 form?
They can complete it. It looks like they're still going to be using the form 941, but it's under Medicare taxes only. If it looks like they need an advance because the Medicare taxes aren't going to cover the amount, We believe that they're going to continue to use this Form 7200 as they did for the Family First Coronavirus Response Act. We think that that will be updated since it's clearly an advance on COVID-related subsidies, but we are waiting clarification.
Okay. A participant had no medical plan when they terminated. The group has had open enrollment since the termination or will have open enrollment during the subsidy period. The participant did not elect COBRA, but will during the subsidy period. Can they add a medical plan and get the subsidy, or is the group only obligated to pay for the coverages they had when they termed?
Okay. I'm not sure I completely understand every part of this question, so I'm going to break it down into parts. If the employee was not on the medical or any COBRA eligible plan when they were terminated, then they are not a qualified beneficiary and not entitled to COBRA or subsequently the subsidies. They were not, prior to termination, they were not covered under the group health plan. However, if employee was on a medical plan and they were involuntarily terminated but did not choose COBRA, but would have been eligible for COBRA anytime between April the 1st and September the 30th, then the plan that they were enrolled in at the termination or the closest plan to it would be used to determine the subsidies, provided they did not make a big change during the open enrollment. As we indicated, we do not believe that the DOL or the IRS is going to limit rights that they previously had.
Okay, somewhat related question here. A participant had no medical plan when they terminated. The participant elected and paid for a dental plan. The group has had open enrollment since the termination and the participant added a medical plan. Will the employer pay the subsidy on this medical plan, or is the group only obligated to pay for the coverage they had when they were termed?
And again, to give my normal disclaimer that the IRS hasn't come out with anything concrete on this, but we believe it is a right that they had during open enrollment. We do not believe, until we get further clarification, that the IRS would take away a right. So we believe that they would be entitled to that subsidy, but again, we're still waiting for the guidance.
If someone is currently on their 18-month COBRA continuation and the group has open enrollment during the COBRA subsidy period 4/1 to 9/30/2021, is that COBRA participant eligible to elect up to a richer plan?
And again, as we've answered, we believe that they would be, only because it is a right that they would have normally had, you know, when they go through an open enrollment period. We don't see that the IRS or the DOL would limit that, but we do not know for sure until we get further guidance. So stay tuned.
Okay. All right. One last question on involuntary and voluntary terminations. Does the re-up provision for COBRA apply to only involuntary terminations?
If you're talking about the COBRA subsidies, it applies to involuntary termination and reduction of hours for employees for participants who have not been offered another group health plan, not took another group health plan, but offered another group health plan, or who have not become eligible for Medicare.
Okay. We do have a few minutes here at the end, Michelle, for a few questions that have come in, a few about dependent care. I just want to let you guys know, if you have contacted myself, Michelle, or our COBRA department in the last couple of weeks, send us questions and we've responded to you, which we have tried to do for everyone. And you do not see your question / answer on this list, it's because we are still waiting for guidance. We are still searching for that answer. And as I said previously, we would rather just say we don't have the available information at this time instead of pointing you in the wrong direction. If you have sent us a question and you have not heard back, feel free to reach back out to us. As you know, things have been coming so fast and so quick in the last few weeks that we are all doing the best that we can to make sure we have the right information out there. Michelle, a couple of questions about dependent care changes. For the mid-year changes and DCAP, I'm assuming the plan document has to be amended and deductions have to be adjusted based on payroll for the remainder of the year. Further, the funds for the DCAP must be available before the funds are released, true?
True.
Okay. Let's see, we have another question here about DCAP. If an employer allows for mid-year enrollment in DCAP, can the employer allow the 10,500 limit for new mid-year enrollees only and restrict the already existing participants to the 5,000 annual election limit?
I don't think that that would be something that would be allowed. If you're going to have an open enrollment, you'd have to allow everybody to have the option. You could not pick and choose your employees.
I got it. What documentation and where should COBRA event history be sent?
For Medcom, we've sent out a letter to the employers, and I do not know for sure what it said as to where we go in the COBRA department. So we'll get our COBRA department to answer you that question for you if you are one of the COBRA, one of Medcom's COBRA employers.
Right. Otherwise, you would just have to contact your administrator. I can tell you.
Yeah.
Right. Do we have clarification yet on who will pay for the initial premium or collect the subsidy for participants on state continuation plans, Michelle?
I think on the state continuation plans, that's from what I gather, and I don't really know for sure that it would follow the same process, but I do not know.
Okay. Does assistance eligible individual have any appeal options if they challenge the event reason, meaning that they believe they were termed involuntarily?
Yes, they would have an appeal process, and we would have to be sending out notices of non-availability of the COBRA and the reasons why.
Okay. We get this question a lot as well. Does the reduction in hours have to be involuntary to qualify for the subsidy?
It does not appear so. When the law came out, it actually talked about that the COBRA subsidy in one space would be available for anyone who involuntarily terminated or had a reduction in hours. So that kind of led us to believe that potentially it had to be an involuntary reduction of hours. But when you read the law further towards the end, it was more clear that it looked like it was just for involuntary terminations and did not include reduction in hours.
Okay. Should COBRA participants who are involuntarily terminated and want to take advantage of the subsidy, should they pay their April premium to the COBRA admin? Will it be reimbursed?
Okay, this is something that we do need to talk about. Because the April is not going to be administered by April the 1st, we're still waiting for model notices. We have until May 31st. If an employee who wants to partake of this subsidy believes that they are going to have a procedure or something that is going to require an upfront pre-certification, or the doctors might verify their insurance, and it would show that if they did not pay the premium, they were not insured. If they do pay the April premium, it has to be reimbursed within 60 days of receiving the subsidy. So that's something that everyone needs to be aware of, is that on April the 1st, automatically the carriers are not going to have, yes, this person is eligible for the subsidy, and therefore they're going to get the subsidy. So it's going to depend on how the employee wants to handle and how it is and what they have in the future that, for testing and everything, that they might want to just go ahead and pay that premium.
Okay. And we mentioned this one a little bit earlier, that, if an employee is involuntarily termed, has a divorce, and the subsidy does not apply to the divorced spouse, correct?
Correct. If the reason that the spouse is on COBRA is because of the divorce, it does not apply to the spouse.
Okay. Also, backup question to this one. If an employee adds qualified beneficiaries to their medical plan and the employee is involuntarily termed, is the subsidy available to all of those qualified beneficiaries?
We believe that it would be, because, again, if they added them to the plan and it was a right that they had to add it to the plan, then we believe they would be entitled to the subsidy.
Okay. And
we're still waiting for IRS clarification, but again, we don't think the IRS or the DOL is going to take away benefits.
Okay. So how do employers update employees' termination reason, if involuntary or voluntary, or employees who have since returned to work?
You have to go back to if they return to work, then they're not going to be entitled to the subsidy if they return to work and they're already on the benefit. So if they've already had the offer of the group benefit and they return to work, then it doesn't need to be updated. However, and that's if they return to your work because you know that they were offered benefits. So they came back within the 13 weeks and they were a rehired employee, not a rehire, but a continuing employee under the ACA. But Medcom did send out for our clients instructions as to how to update and how to let us know if they were involuntarily terminated.
Thank you, Michelle. And thanks everyone else for joining us today, for submitting your questions, for being patient for answers, and as always, for trusting Medcom to be here and to answer them when they come up. If new guidance is coming out, if we see that in the next little bit, please count on us to have another session. We will post information on our social media outlets and on our website via our Medcom blog. And we will contact you through our email contact list if we are to have another session with updated information. Michelle Barki, thank you so much for the work that you've put in on answering these questions. And thanks to everyone for attending today. We will be sending out the recording and this slide deck as soon as possible. We hope you guys have a great rest of your day and rest of the week. Thank you all for attending today.